Amanda Jones, expecting it to be a short morning, appeared before
Judge Hartzell had other plans.
This is case number 251740
expecting it to be a short morning.
Nick Carnes on behalf of the people.
This is case number 251740SM. We are set for a pretrial conference. It appears we have a resolution in this matter, Mr. Carnes.
Yes, Your Honor. It's my understanding the defendant will be pleading no contest as charged. The people are supporting a delay of sentence. The full dismissal of the defendant is successful on the delay. Success on the delay would be whatever programming is recommended by probation and violation. Successful on the delay. Probation. Success on the delay would be whatever programming is recommended by probation and yes, violation. And the reason for the no contest plea is potential civil liability. Yes.
Okay. And so just so we're clear, the success with completion of programming. And so just so we're clear, the no violations. Success with completion of programming. Mr. Hartzell?
That is accurate, Your Honor.
Okay, no violations. Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
That is accurate, Your Honor.
Will you please raise your right hand? You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth. Is that how you wish to resolve it? Will you please raise your right hand? Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500 and consecutive sentencing may be imposed if the offense happened in a place of confinement. Now, along with that, there's what's called a Killebrew agreement, and what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence, and if you're successful with that delay of sentence, the case would be dismissed. Dismissal success means that you complete all the programming that your probation officer requests that you do, and you not have any violations. Do you understand that? Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that? Now, additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you were going to plead guilty and this person sued you, that guilty plea could be used against you. So no contest plea means that it's not. Essentially, you're accepting responsibility without saying that you did it. Do you understand that? And is that how you wish to proceed?
Yes.
Essentially, you're accepting responsibility. March 31st of this year, were you on probation or parole? And is that how you were you on bond in any other file?
No.
Back on May, Ms. Jones, to the offense that on or about were you on bond in any other file? March 31st, 2025, here in the city of Cadillac in Wexford County. How do you plead to committing the offense of assault and/or assault and battery? March 31st, 2025, here in the city of Cadillac in Wexford County. Counsel, I've been provided with a Cadillac Police Department report, incident number 2500819. It's been marked as People's Exhibit number 1. Mr. Carnes, do you move for submission?
Yes, Your Honor.
Mr. Hartzell, 819. It's been no objection then. The People's Exhibit number 1 is received. Give me just a moment to read that. No objection then. We are back on the record. I've had the opportunity to review the People's Exhibit number 1. Do counsel believe that it forms a factual basis in which to accept the plea and the court rules have been complied with?
Yes, Your Honor.
Do counsel believe that it forms a factual basis in which I find the plea is knowing, voluntary, and accurate? As such, Ms. Jones, I find you guilty of assault and/or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by the old, what's commonly referred to as the old dam The court can take judicial notice that is located here in the city of Cadillac, and it is between Main Street and River or Wright Street on the what's now known as something along the lines of the Green Trail or the Green Pathway. River or Wright Street. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged the victim is a 14-year-old middle schooler that Ms. Jones posted another video on TikTok captioned round 2 in the police report. And this appeared to be all over some things that were said about another's deceased mother. Round 2. As such, I find that the elements are made out from assault and battery, and that this would have been an unwanted, forceful, violent. As such, I find that the elements are made out. Additionally, I believe the interests of justice are well forceful, established here in allowing the defendant to plead a no contest, so as to not have her guilty plea used against her should a case of civil liability arise. Although I question what the civil liability would be since there's no injuries, but I guess that's not for me to determine. Case of civil
Pause for a second. You just heard the words Killebrew agreement and delay of sentence, and unless you work in a Michigan courtroom, they probably meant nothing to you. They are the entire reason we are here. So let us slow down. Probation, delay of sentence. If she finishes the programming and stays out of trouble, they probably meant nothing to you. No conviction. They are the entire reason we are here. Clean slate. So let us slow down for good behavior. If she finishes the programming and stays out of trouble, the judge does not have to take it. No conviction, away from it, no record. Withdraw her plea and start over. Exchange for good behavior. Brings us to Judge Hartzell. It is only a recommendation.
Mr. Carnes, are we able to sentence today?
If he walks away from it, she can withdraw her plea and start over.
Yes.
Which brings us to Judge Hartzell.
Anytime it's
Mr. Carnes, are we able to sentence today?
Especially for civil liability.
Mr. Hartzell, any allocution?
Yes, for obvious reasons. But what I will say, anytime it's my client has, to my knowledge, for civil liability, I stayed in constant contact with the defenders for obvious reasons. And what I will say, my client has, to my knowledge, strong ties to the community. I have stayed in constant contact with the defender's office. She's highly motivated to do well and receive the best she does have delay. Strong ties in any situation that will advise my clients if they don't do well. She's highly motivated to do well and the losses delay don't delay. In these situations, she wants to be able to, if they don't do well, there is the risk of jail later if the losses delay. She's aware she owes some money on she wants to be able to, she's going to pursue to await various careers and ambitions. At the moment, she's working on pseudo friends with her. She's aware she owes some money on hold throughout these procedures, and I don't doubt will await the support for her as well. I asked the court to, the court will be supportive throughout these procedures, and I don't doubt will continue to be supportive of her as well. I asked the court to fully kill the 14-year-old. Really shows judgment lack of security incident. However, the defendant does not have clearly shows convictions that lack of judgment, lack of security. However, the defendant does not have Jones on a delay of sentence. Prior convictions, I think ultimately this is a fair resolution of the file. I'd ask the court to place.
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not? Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Your Honor, I don't show that knowledge. She was the defendant, and I'm familiar with the court has.
Well, I'm just trying to remember. I remember seems like climbing on top of the school for the 4th of July. Was there charges on that? Well, I'm just trying to remember. I remember seems like climbing on top of the school for the 4th of July. Was there charges on that? I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally, I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. In a fetal position, she's an 18-year-old because of something that was said about somebody else's deceased mother, and then had the gall in a fetal position to post another video of it because of something that was said about somebody who's making a mistake. That's not had the gall or post another video of it on TikTok. A delay of sentence is to allow making a mistake. Determine whether or not the person should or be successful on determining delay in sentence. The delay of sentence is to allow the court to determine whether or not the person plans from what I've seen from on a term delay in sentence. And if you tell me that charges weren't brought through with the plan. I trust you on that, from Ms. Jones. I can tell you, and I'm not, and Mr. Carnes, if you tell me that any of my prior charges weren't brought, knowledge, because clearly it's not. I trust you on that, but I do know, tell you, and I'm not from my time as the elected prosecutor, any of my prior and knowledge, because clearly it's not judge. And I believe she has another case coming up that she has to be arraigned on Judge Hartzell, because I had a conflict on that because I was the elected prosecutor as judge. And I believe she has another case coming up that she has to be arraigned on Judge Hartzell, because I had a conflict on that because I was the elected prosecutor when that, whether it's this court or the probate court or somehow tied with other events. Ms. Jones has been. I'm not going to make a decision today. What I'm going to do is I'm going to set this over for sentencing, or somehow tied with other parties the opportunity. I'm not going to make a decision today. Convince me why. What I'm going to do is I'm going to set this over for sentencing, but I'll allow both parties the opportunity to do sentencing memorandums and try to. As I sit here today with the information I have, I cannot, in good conscience, but let this just get, for all intent and purposes, swept under the rug.
Most people assume
as I sit here today with the information I have, I cannot, in good conscience.
This case proves that is completely wrong.
Purposes,
a judge does not work for the prosecution. That when both attorneys agree on a deal, the judge is just there to sign off. A judge is the only person in that room who answers to the public. A judge does not work for the prosecution. When a deal lands on the bench that does not account for what the public would expect from the justice system, a judge is the only person in that room who answers to the public. That is what happened here. And when a deal lands on the bench that does not account for what the public would expect from the justice system, they presented every right to push it back. And the judge looked at the person standing in front of him and decided the package did not match the conduct. They negotiated. They agreed. You do not get to kick a 14-year-old on camera. Caption the judge looked at the person standing in front of him and decided the package did not match the conduct. You do not get to realize every post was another exhibit. Caption it round